Hi, this is the Business Guy. We're going to talk about real estate asset protection. We're going to have a little fun with this video.
Fun? Yes, fun.
We're going to do the first part in my studio here, and then we're going to go out in my backyard and finish the rest. Hello, airplane. So who am I to talk about this? I'm the CEO of Asset Protection Planners and Lawyers Limited, the nation's largest asset protection company. We have attorneys and consultants on staff who you can call so you can put together an asset protection strategy that's right for you. Now, strategies to protect real estate from lawsuits include forming land trusts for privacy of ownership. They also include the proper use of LLCs for asset protection and lawsuit protection. In addition, they also may include the use of equity stripping liens to make the confiscation of real estate less likely. So this video discusses various real estate asset protection strategies. We'll talk about how to protect your home from lawsuits and how to protect your investment properties. So we'll describe the different asset protection strategies for real estate. So by the time you're done watching this video, you'll know exactly what to do. And then when you're ready to proceed, go ahead and give us a call and you can speak with one of our in-house attorneys or consultants. We can help guide you step by step to set up an asset protection plan that's right for you.
You should call them.
As a little background, our company was incorporated in 1906 and our company has tens of thousands of clients who have trusted us to structure solid asset protection strategies to safeguard their property. And as you'll see, each element of the plan protects your assets, provides privacy, or is a deterrent for a legal opponent. In addition, we have viable strategies that secure liquid assets as well. Okay, so let's talk about real estate asset protection strategies.
The first element.
The first element of this asset protection strategy is privacy of ownership. To accomplish this, we establish a land trust for each property. You're the beneficiary of the trust, or you control the LLC that is your trust beneficiary. As such, you can sell, rent, refinance the property as you wish. Thus, you essentially have as much control as if the property was in your own name. The land trust holds title to the property. So first we complete the land trust, and then we complete the deed that you use to transfer the property into the land trust.
That's interesting.
Now, you keep the land trust, thus the name of the beneficiary, in your filing cabinet at home. You record the deed in the county recorder's office in the county where the property is located. The deed is the document that transfers the property from its current owner, you for example, to your trust. Again, the first thing you gain here is privacy. That is, the property is titled to a trust and not to you.
Why do you do that?
So why do we do that? Okay, since you asked, here's the answer. Before a law firm makes a plan to pursue you as an individual, they usually run an asset check to see what's within reach. This is as simple as searching the public records to see what you own. Thus, with your property titled to a properly drafted land trust, your name won't come up in a routine asset search.
And his name?
No.
Number two, asset and liability protection. So we've addressed how to hide ownership of real estate through the use of land trusts. Next, we address asset protection and limiting internal liability. That is, liability that your assets create. And we do this by establishing limited liability companies. That is, we file LLCs, for instance, a tenant or guest slips and falls. A loose wire causes a fire that injures someone. Somebody trips on a loose carpet, or somebody walking by who needs money intentionally injures themselves on your property in order to sue you.
I will sue you.
To protect yourself, the LLC is the most common candidate. So we make the LLC the beneficiary of your land trust that holds title to your property. And we use the LLC on investment property, not your personal residence, because that's in a different tax category. So for the land trust used for your personal residence, you'll usually remain the beneficiary personally. But with investment property, we set up an LLC to act as beneficiary.
Now that is perfect.
Okay, now number three, equity stripping. One final measure that acts as a powerful deterrent to creditors is to set up a separate LLC and have it mortgage the equity in your investment property. Now, this is a publicly recorded equity line of credit type of mortgage or deed of trust recorded in the county recorder's office against each property. Doing this strips the equity out of your properties. Then when the quote bad thing happens and you're in legal hot water, we transition to phase number two. Have you ever gotten a letter from a bank saying, in effect, we just bought the mortgage on your property, so start making monthly payments to us now? It's very common to have one bank buy a mortgage from another bank. So here's what we do. We first establish an offshore trust that's beyond the reach of the local courts. We have a lender offshore that will buy the mortgage and place the proceeds into your offshore trust. Thus, you have a statement that you can show the judge that shows a third party has purchased the mortgage and that you receive the proceeds in your offshore trust. And naturally, you would not be able to scoop up the money and run. That would be too risky for the lender.
Really? That's great.
But keep in mind, before doing this strategy, you were not able able to spend the dead equity in your property anyway. After all, it's just equity. You can, however, generate spendable cash in the future if you sell or refinance the property. Doing so will pay off the mortgage and generate liquid cash in your offshore trust that you can access as you wish. The real test. Okay, here's the real test. Does this work in the real world? We have people ask us all the time, when somebody sues you, can they take your house? And the answer is
Yes.
now, there are some states that have better homestead protection to protect your personal residence than others. Florida and Texas come to mind. But it's one thing when a lower court rules on a case, but what really holds weight is when the Court of Appeals issues a ruling. For example, when a ruling issued in California by the Ninth Circuit, it is binding precedent for the lower courts in that circuit. They must follow it. Plus, it is persuasive precedent for the other circuits and for the state courts. They are more often than not persuaded by the reasoning of that ruling. That said, the California Court of Appeals ruling strongly supports the strategies that we just talked about above. See Nautilus Inc. versus Yang. In that case, the plaintiff, Nautilus Inc., got a judgment against the defendant by the name of Stanley Kuahoa Yang. Nautilus attached the judgment to a home that Yang owned. The family had a mortgage recorded against the house, and another company, in turn, bought the mortgage from the first lender. As a result, Nautilus filed suit. They filed the suit against Yang, and Yang's father took title and helped his son get a loan. The original mortgage, plus the company that bought the mortgage, were also sued.
So what happened?
First, the lower court ruled that the one who recorded the mortgage and the lender who bought it acted in good faith. The California Supreme Court also affirmed this ruling, and they cited Civil Code Section 3439.08a. The liens held firm and could not be invalidated. Okay, number 4, estate planning. The structure continues to grow in detail here with some estate planning tools. We establish a living trust, and then we take the beneficiary entities such as the LLC and associate them with the living trust, so that when the members die, the membership interest in the LLC automatically goes into the living trust. The living trust allows you to specify exactly who or what receives your assets upon death. It also reduces your probate costs and could substantially reduce your estate taxes. At this point, you've placed your investment property into land trusts. The beneficiary is a legal entity, such as an LLC, and a living trust becomes the member of your LLCs upon your passing. So you have privacy, internal liability protection, lawsuit and asset protection, and estate planning all bundled together in your asset protection strategy.
That's amazing.
Okay, so how much asset protection do you need? One of the most common questions we get is, how many legal entities do I really need? And that really depends on how much each property is worth. The average home in California will be worth more than the average home in Iowa. Ideally, you'll want one LLC per property. With this arrangement, it helps to prevent a lawsuit from taking all of your real estate at the same time. Thus, you have each property protected in its own LLC cubbyhole. In general, you may want to limit the amount of equity per legal entity to around $200,000 or so. Typically, we will put each piece of investment property into a separate land trust. Then a separate LLC will be the beneficiary of each land trust. The land trust gives privacy of ownership. The LLC provides asset protection and lawsuit protection. When somebody sues the LLC owners personally, there are provisions in the law that can help prevent the creditors from taking the LLC or anything inside. In many states, to enjoy such protection, an LLC must have 2 or more owners. But that second owner can be another company of yours. The LLC can also act as a lawsuit shield when somebody gets hurt on the property and sues you for more than your insurance covers. It can help keep the lawsuit within the LLC and away from you personally. Now, the Garn-St. Germain Depository Institutions Act of 1982 says, in short, that you can transfer from 1 to 4 dwelling units into a trust without the bank calling the loan due. Now, there are a few more details here, but we have never seen a lender invoke the due on sale clause when somebody has placed a house into one of our land trusts. So let's say you have a personal residence, 4 rental homes, and 3 fourplexes. Each can go into a separate land trust. And if you read the law we just talked about, you'll see you do not need to get lender permission in order to move these properties into land trusts. It's also recommended that you advise your insurance company that you move the property into trusts. So what's the conclusion here? Using the right tools can mitigate your liability. For a legal opponent planning to sue you, you've placed multiple roadblocks in their way.
A roadblock.
You have hidden, protected, and stripped the property of its value. Hello, airplane. And in the end, there isn't a prize for the hungry predator looking for his or her next meal. And you've also created an estate plan for yourself and your loved ones. To learn more or establish your own real estate asset protection strategy, visit assetprotectionplanners.com for more free info, or give us a call at 954-400-1050. And the sooner you get started, the better it'll be for you when the process server shows up at your door. Please like, subscribe, and share this video. We'll see you next time. This is The Business Guy.